Good afternoon. Thank you for attending Meyers Nave's webinar on California's new marijuana law. How does it impact employers? Presented by Gina Roccanova. A few things to get us started for today's webinar. All of your telephone lines are muted. On the top of your screen, there's a Q&A button. During the webinar, if you would like to ask our presenter a question, please submit your questions using the Q&A function. Gina will do her best to answer all questions during or at the conclusion of the webinar. We have quite a few attendees registered today, so if your question isn't answered, we will follow up with you after the webinar via email. We are offering CLE credit for this webinar. CLE certificates and a copy of the PowerPoint slide deck will be emailed to all attendees next week. And now for our webinar. While medical marijuana has been legal in California for 20 years, employers face a whole new set of challenges with the advent of legal recreational marijuana. With the passage of Proposition 64 in November of 2016, California became the most populous state to legalize recreational use of marijuana. Now that it is legal, what can employers do to regulate on-duty and off-duty use of marijuana by their employees? This webinar will tackle the evolving legal and scientific challenges related to drug testing, policies for on- and off-duty marijuana use, medical versus recreational use, employees and jobs that impact public health and safety, safeguards for policies that treat marijuana like prescription opiates, accommodation requirements in chronic medical conditions, and other issues. Through a detailed overview of the existing law and presentation of various alternatives for policymaking, this webinar will help employers to understand and avoid potential legal pitfalls, develop practical workplace situations that take into account the realities of the labor market, and implement compliance strategies to mitigate legal risks. Gina Roccanova is a principal at Meyers Nave and chair of the Labor and Employment Practice Group. She serves public and private clients with more than 20 years of experience in negotiations, counseling, litigation, arbitration, and training. She is well known for her ability to communicate and create an atmosphere of trust in stressful, high-profile situations. Gina, thank you for being here with us today.
Thank you, and thank you everyone for calling into the webinar. I hope it proves useful. I see a few familiar names on here, and I wanted to give a particular shout out to the City of Santa Ana, who has their entire personnel department on the line. So I hope it proves worth everyone's time. I want to encourage everyone to send in your questions throughout the presentation, and I will do my best to answer them. I particularly appreciate people sending in questions during the course of the presentation. This way I get a sense of where all of you are starting from and what your interests are, and I can kind of take things in the direction that you tell me. This way I'm not just blabbing at you for an hour or so. So let's jump right in here. Here's what we're going to cover in this program. Hopefully we're going to do a little bit of discussion about the current state of the law. We're going to talk about employee use and drug testing policies and hopefully give you a few different options to consider as things continue to evolve in this area. And some policy frameworks that various employers have found helpful in various situations. Keep in mind that, there is no one-size-fits-all policy that's going to work for all employers in all situations. So, as is the case anytime things are in flux, it requires a little bit of thoughtfulness, but obviously you already have that since you're attending this webinar. Okay, let's start with some statements that I've actually seen asserted in various articles here and there about this topic. We're going to start off our presentation with just putting them out there, and then at the end of the presentation, we're going to give you the answers as to whether each one of them is a myth or a fact. So here's our first one. Myth or fact? Employers are required to have a cannabis policy. Is that a myth or a fact? Here's another one. Because drug tests cannot measure impairment by marijuana, employees cannot be fired for a positive marijuana test. The next one, myth or fact. use of medical marijuana must be accommodated under the California Fair Employment and Housing Act. Maybe a myth, maybe a fact. Let's find out. Here's another one. Employees cannot be fired for being impaired on duty. Myth or fact? And the final one, employees cannot be fired for being impaired off duty. All right, let's tackle each of these, and let's see if this webinar will provide the answers to those questions. The current state of the law right now. So our forecast is slightly cloudy, but clearing late in the day. Right now, we've got a number of moving parts here. We've got the Compassionate Use Act, which has been around for more than 20 years now. We've got a seminal case called Ross v. Raging Wire Telecommunications that we're going to talk about. You had the voter-enacted Prop 64, the Adult Use of Marijuana Act. You had the Medical Cannabis Regulation and Safety Act of 2016, which then got kind of wrapped up in the subsequent SB 94, also known as the Medical and Adult Use of Cannabis Regulation and Safety Act, which the legislature passed this past year and signed into law in June 2017. And then overlaid with that, you've got this patchwork of local regulations around zoning, cultivation, distribution, et cetera, et cetera. Most of the local regulations they're not going to be the focus of our presentation today because they don't really affect you as employers. All right, so let's kick this off with just the bare bones of a hypothetical situation here and hold it in mind for, various policy approaches that we're going to talk about later. So here's your hypothetical. You have an employee who approaches the ADA coordinator, provides a copy of his cannabis recommendation card from his doctor and a note stating that the employee is undergoing chemotherapy and is using medical cannabis to alleviate the symptoms related to the chemotherapy, the side effects. This is a long-term employee, a terrific worker, very well loved. There's absolutely no desire to see this person go or to, see him suffer at all. So what do you do? Let's hold that thought for a minute as we talk about the legal underpinning. So as I mentioned, starting with the Compassionate Use Act, this was enacted more than 20 years ago. We've been living with Prop 215 or the Compassionate Use Act. And when it was first passed, there was a huge flurry of questions about, well, now what do we do with accommodation? Do we have to accommodate the medical use of marijuana? The courts answered that question after not too long, and that sort of put an end to that question for the time being. But there's still sort of stirrings around it, and the, that state of the law could eventually change. There are still many unanswered questions around the Compassionate Use Act, if you can believe it. So, under the, as amended, California Health and Safety Code, employers are not required to allow the use of marijuana in the workplace or during work hours. Very clear. Under Ross v. Raging Wire Telecommunications, the courts said employers are not required to accommodate any use, even off-duty use, for medical reasons and the privacy of an employee's home. Employers are not required to accommodate that. And the reasoning of that case was as follows. FEHA, the Fair Employment and Housing Act, does not require employers to accommodate the use of illegal drugs, and marijuana was and is still illegal under federal law. The Compassionate Use Act didn't address the employment situation at all. It just eliminated, it decriminalized the use of medical marijuana, and it only, obviously decriminalized it only at the state level. Moreover, the public policy articulated in the Compassionate Use Act did not encompass an employer's action and did not require an employer to accommodate the use of medical marijuana. So that was the court's holding in Ross v. Raging-Meyer, and therefore the state of the law before Prop 64 was that you had this clear statutory language, you had that court's decision, and therefore employers were permitted to prohibit any marijuana use on or off duty. Clear, bright line. Here's the good news. Nothing that has passed since, not Prop 64, not SB 94, none of that changes this, that employers can still prohibit any marijuana use on or off duty. To the contrary, not only did Prop 64 not change that, it explicitly put into the statute the holding in Ross v. Raging-Meyer and preserved the right of employers to maintain a drug-free workplace and explicitly states that employers do not have to accommodate, quote, the use, consumption, possession, transfer, display, transportation, sale, or growth of marijuana in the workplace. What's interesting is that there are a number of pundits, despite the fact that acceptance of recreational marijuana use has been rising steadily for a long time now, quite a few political commentators credited this language with the success of Prop 64 because the prior efforts did not include this language, and therefore a number of employer organizations came out against it. So the inclusion of this language may have had something to do with the passage of that proposition. So as I mentioned, SB 94, which was passed this past year, also does not change the rules for employers. In fact, it doesn't talk about it at all. It covers licensing and cultivation, distribution, transport, safety, water rights, appellation like wines, butter. Yeah, there's a whole section on butter, and medical privacy, but it doesn't talk at all about the employment relationships. However, there is one provision in SB 94 that jumped out at me as potentially, ultimately having an impact on this whole thing, and we'll talk about what that is later. Just to mention two areas that will likely not affect the employment calculation at all. One is local regulations, as I mentioned before. Those are, largely rules around what can happen in that jurisdiction as far as cultivation, distribution, et cetera. Local regulations don't affect the basic proposition that it is legal for adults over the age of 21 to possess certain amounts of recreational marijuana. There's also been a lot of discussion lately about the Department of Justice directive just last week that abandons what was known as the Cole Memorandum and leaves discretion to the various U.S. attorneys as to whether and at what level to prosecute federal statutes prohibiting marijuana and scheduling it as a Schedule I drug. For those of you who care, the Cole Memorandum was an Obama-era directive or opinion that basically took a hands-off approach and said that in jurisdictions and states where marijuana was legal, that the U.S. attorneys were not going to interfere with that. The withdrawal of that directive and the new directive gives U.S. attorneys more discretion as far as prosecution, but again, it's not really going to impact the employment situation. It's more likely to impact the industry as a whole. So I wouldn't accept to the extent that you have an academic interest in this area. I wouldn't worry too much about it, although I'm more than happy to answer questions about it because I'm a big geek and I find this very interesting. Okay, let's talk about employee use and drug testing policies. So here you've got a whole bunch of different issues that need to be considered when you're developing and implementing such policies. So you got to look at your existing policies, assuming that you have them. You need to think about employee perception. So, you know, let's recognize that times are changing and attitudes are changing, and they're changing at different rates in different communities and among different sectors of employees. You know, I imagine certain creative industries in the private sector are having to deal with this way faster than those of you in the public sector, especially like public safety departments. We'll have to think about testing protocols. There's also continued and perhaps even growing interest in medical applications. You know, there's still a lot of pressure from various parts of the medical community, for example, for the, you know, federal government to change cannabis from a Schedule I drug because there are, according to large sectors of the medical community, medical uses for it. And then obviously, you know, for the large number of employers on this webinar that have unions as part of their environment, those collective bargaining agreements and MOUs, you know, those need to be considered as well because a lot of this stuff is going to be considered within the scope. So as you can see, you know, although the law hasn't really changed anything, there are a lot of moving pieces here. Law isn't really the agent of change here, but that doesn't mean that there aren't changes happening. I put testing at the center of the whirlwind because there is so much interest in it and because there is so much controversy over it. And I would argue that, you know, in an ideal world, those testing protocols would not be at the center of everyone's concerns. And I'll explain why as we go along. If I can say, though, suggest, though, that if there's one takeaway from this presentation, well, the two big takeaways, I would say. One is that the new laws aren't changing anything. The other is don't think testing is going to solve all your problems. There are legal and scientific limits that make it a far less useful tool than people may think. So, first place you're going to look is your existing policies. Do you have one? And if you have one, do people know what it says? And has it been enforced? And how has it been enforced? And have there been unofficial or sort of past practices that have sprung up along the way about how it's been enforced in certain situations? For example, if you are in an agency that has reasonable suspicion testing, and your practice has been that if somebody tests positive and they indicate a desire to go through a rehabilitation program, they will be given a last chance. Is that written in your policy, or is it just sort of a custom? This is a good time to think about that. Do your policies need updating or clarification? Even if you don't have a policy that needs updating, you like it a lot, fine, keep it. People may need to actually know that that is still your policy and it hasn't changed. And, you know, a lot of public agencies and private sector employers have sort of a boilerplate policy, and it's a good time to think about whether that still works for you. The answer may be yes. The answer may be no. It's a good time to give it some thought. As you think about your policies, here's some issues to keep in mind. On-duty versus off-duty use. Are you going to treat those the same? You can. You don't have to. Medical use versus recreational use. Are you going to treat those the same? You can. You don't have to. Obviously, if there are jobs in your agency that impact public health and safety, those will probably need to be treated differently, or at least have different considerations that will inform your policy. And yes, it is okay to have different policies for jobs that do impact public health and safety. You want to think about accommodation and chronic medical conditions. Again, you don't have to accommodate marijuana use as a treatment, but maybe you want to because attitudes are changing, because your workforce demands it, or for whatever other reasons. This is something to think about. Another issue to consider, as I've been previewing, like in bright neon, the legal and scientific limits of drug testing. We really need to think about that as we think about how our policies are going to be implemented and applied. And then certainly, do you have any federal contracts, or are there applicable federal regulations? So, transportation districts, I'm looking at you, your people are going to be subject largely to DOT regs, and if that's the case, all bets are off. You don't have this kind of discretion. Not only, don't you have to accommodate marijuana use, you can't if you are subject to those regulations. So the first of those, on-duty versus off-duty use. As I said, you don't have to allow either one. You may want to think about safety concerns, particularly for on-duty employees. There are arguably safety concerns even for employees not doing safety-sensitive jobs. If you are, uncoordinated, if you've got, enough marijuana on board that you're likely to injure yourself, that's a safety concern. And so I have yet to encounter an employer that permits on-duty use. Your mileage may vary. Public perception and community standards. The answer is not necessarily going to be the same in San Francisco as it is in Fresno, as it is in Turlock, as it is in San Diego. Every community has its own way of going about dealing with these issues, and you probably want to, as you think about your labor pool, as you think about your employee groups, those are all things that are going to play a role in your decision-making on these policies. Similarly, in addition to the greater community, you have your own workforce culture. And that can vary from department to department, and that certainly varies from community to community. As you think about these policy decisions, don't forget rules like secondhand smoke. If you can't smoke tobacco, you can't smoke marijuana. Moreover, under Prop 64 and SB 94, you still cannot use marijuana in public, and a lot of people seem to overlook that. What is permitted is private use. So it's not like you're going to have people sitting around a pub passing around the brownies or the pipe or whatever. That's still criminalized. You still can't do it. There's also rules about open container that people may not be aware of. You cannot have an unsealed container of any kind of cannabis-related substance in a car. I do occasionally get the question, what about Labor Code Section 96K, which says that employers cannot take any action on the basis of legal activity? First of all, 96K doesn't create substantive rights, which is something that the courts have said numerous times. The other answer to that question is that you have a more specific provision under the Health and Safety Code, which directly addresses an employer's ability to take action against an employee, even for legal use of marijuana. So because the specific governs over the general, I would say 96K wouldn't apply here. So the next consideration you want to think about, medical versus recreational use. Can you treat them differently? Yeah. Should you treat them differently? It's up to you. with the provisos that I mentioned before, like if you're subject to, federal regulations and all of your employees are subject to DOT regulations, you might as well just leave the webinar now, because I have nothing left for you other than that's what you have to do, is comply with those regs still. Okay. So, as I mentioned, there is no obligation to accommodate the use of even medical cannabis on or off duty for someone who is disabled and is using that as a medicine. However, you still have an overarching duty to accommodate the medical condition, and so it can be difficult to tease those apart. And if you can't come up with any accommodation that will allow someone to continue working for you, and you've decided not to accommodate the marijuana use, you have the better argument. You have the right to do that under the law, but you always want to have in the back of your head the way these things end up playing out, the way they can be perceived by juries, again, as these community standards continue to evolve, et cetera. Keep that in mind. If you do choose to allow someone to use or to deviate from a policy that otherwise prohibits on or off-duty use of marijuana, then we're in accommodation land, and you need to follow the rules about what information certifications you can require. Can you treat it like any other medication? My advice, my suggestion would be, yes, you follow the same rules as you would with any other medication that could impair someone's cognitive and physical functioning. So, there's a number, obviously, of health and safety concerns that need to be taken into account when deciding what your marijuana policy is going to be. As we mentioned, subject to DOT regulations and game over, that's it. But there are other safety-sensitive positions that aren't subject to those regulations. What are you going to do with them? Are you going to prohibit it off-duty but allow it, prohibit it on-duty but allow it off-duty? That is a policy choice you can make. There might be some reasons you may not want to make that choice. What about employees who engage in occasional driving or just commuting? That's a big one. There is, and with the proviso, understood that correlation does not necessarily mean causation. When the state of Washington legalized recreational marijuana, there was a subsequent doubling of traffic deaths. It's not clear whether there was a causal relationship there, but it's something to keep in mind, especially given that traffic accidents are the #1 cause of work-related fatalities in California. So if you have employees who are driving, that is definitely something to take into account when deciding what to have as your medical and recreational cannabis policies. And then obviously under the law, keep in mind that as an employer, if an employee is acting in the course and scope of their job duties and acts negligently, including whether they are under the influence of any intoxicating substance, you as an employer could end up having liability for that, for their actions. Now let's get to a particularly juicy part of our presentation, and the one that people tend to have the most questions about. I haven't seen any questions pop up yet, but jump right in if you've got them and I'm not answering them. Are the legal limits on testing. So as I mentioned, DOT has its own set of regulations. If you're subject to them, you follow those. On occasion, there are also government contracts and grants that have provisions related to employee and drug-free policies, testing policies. A federal regulation is going to trump our local requirements on that. You may, and here's where we have to tread very carefully, employers under the state constitutional protection of employee privacy, which is generally considered broader than the federal Fourth Amendment, the courts have concluded, the California courts have concluded, that a pre-employment drug screening program that is applied to all applicants is okay. It is legal. There is one Ninth Circuit case from 2008, the Lanier case, that concluded that a pre-employment drug screen for a library page violates the Fourth Amendment. And if you look at the logic of that case, and it analyzes the circumstances as if the employee were a current employee and not an applicant. And so I want to let you know that that case is out there and has been largely ignored because I think there is a sense that it's a bit of an outlier and it's not terribly well reasoned. But obviously I want you to know that it's out there because, you know, that's the current state of the law in the Ninth Circuit. So if you're going to have a pre-employment screening program, there are a few, as public employers, those of you that are public employers, private employers, you can just do it, no problem, because you're not subject to the Fourth Amendment. Public employers probably want to proceed a little bit more carefully in this area, have, take it on a job-by-job basis and have some articulated concrete reason why you would be conducting pre-employment testing, and sort of, make sure that it's solid reasoning. It's a little bit riskier for you, I'll say that. Reasonable suspicion testing is also okay, and that includes post-accident testing. The courts have affirmed that numerous times, that post-accident testing is reasonable suspicion testing, and it's okay. If you're in San Francisco, different rules apply, but everywhere else, it's okay. You can also engage in legitimate job-related medical screenings, and here again, you want to proceed very carefully because there are limits on that. What it can't do is be a backdoor to random drug testing, because random drug testing is not okay in California. You can have a random screening program for certain safety-sensitive positions. It is a bargainable issue, and it's an area where you want to get legal counsel before you go in that direction if you haven't already vetted your program. So now let's talk about the real problem with testing in this area. The real problem is that a drug test, when you're talking about marijuana, is not going to tell you very much. It can tell you that the person you've tested at some point in the past ingested marijuana. It cannot tell you when. It cannot tell you how much. It cannot tell you what form. It can't tell you the concentration of THC. Right now, the tests that are available for marijuana, quote unquote, test one metabolite of THC, and it's not a particularly accurate test. The other problem is that marijuana is metabolized very differently from alcohol. So alcohol, it's a sort of a straight line metabolism. It goes into your bloodstream and your body, metabolizes it over time, and it happens at a pretty constant rate. Marijuana gets stored in fatty tissue. Different people experience it in different ways. They have different levels of impairment, even based on, like two people, same body size and general composition are going to potentially process marijuana through their bodies differently. Some of it has to do with frequency of use. Some of it just has to do with their fatty tissue and where it is, but you can't tell from a test if or when someone was actually impaired by marijuana. That is just not scientifically available to us. The one sort of, potential ray of hope, that ripple that I mentioned from SB 94, one of the provisions of SB 94 relates to a standardization of and testing of the concentrations of THC, in particular marijuana products that are going to be sold. And, I'm not a scientist, so take this with a grain of salt, but I wonder if that is an area that it may eventually lead to more accurate testing. Who knows? But right now, there isn't one. So, how can you tell if someone is impaired by marijuana? The answer is the old-fashioned way. So a test can be one piece of evidence. It can't be the only piece of evidence, and particularly if you have employees who are subject to a just cause standard for whatever reason. And you're in arbitration, or you're not going to march in there with a drug test and think that's the only piece of evidence that you can submit. But, marijuana has a particular odor, particularly when it's smoked. And certain manifestations, certain symptoms of marijuana intoxication, like red eyes and lack of coordination. So, you have an employee who walks in, stinking of weed, maybe red, runny eyes, and stands there and giggles for 20 minutes, and then their test comes back positive. Well, then you've got a pretty decent case that this person was actually under the influence of marijuana at the time. So I think it's the moral of the story is tests can be a part of the puzzle, but they're not going to solve all your problems. Another little side issue here, and again, it's not going to really impact any of you, but it's an interesting legal issue. It has to do with union organizing of the cannabis industry. So Prop 64 requires that employers in the cannabis industry are neutral when it comes to union organizing. And in fact, the United Food and Commercial Workers have been devoting considerable efforts to organizing employees in that industry. So, okay, so far so good, right? Employers have to be neutral. The organizing effort underway, they present their cards, the employer says, fine, we will negotiate with you. However, that's never the end of the story. There are always disputes over alleged unfair labor practices or unit determination or what have you, and so who adjudicates those in the private sector? That would be the NLRB, the Republican-dominated federal agency in a federal government that just said that it's not going to cooperate with states that have legalized marijuana. So it's, if you see this issue popping up, grab your popcorn because it's going to get interesting. Okay, back to what affects us. Shifting winds. So again, this is going to probably hit the public sector last, and I think most of you are in public sector agencies. But we've got to recognize the reality that public acceptance of both medical and recreational uses of marijuana continues to increase. I walked by a dispensary in San Francisco yesterday, and I kid you not, there was a line out the door, and these people were like grannies and like middle-aged guys in suits and just all walks of life. It is becoming much more part of our reality. Prop 64 passed with 57% of the vote. That's a pretty big margin. We're not the first state to do this. It seems to, have resulted in the sky not falling in Colorado or Washington despite the increase in traffic deaths. obviously, a lot of local jurisdictions are recognizing that there are some significant revenue upsides in this whole industry. And, according to the Public Health Institute, a research group, and this study is a few years old already, 1.4 million Californians, this was before Prop 64, so 5% of adults in California had used medical marijuana. So that should give you some indication of the way that this is becoming accepted and acceptable in our state. Obviously, there are some headwinds in the other direction. A lot of those coming from the feds. So, you had the Cole memorandum. That is no longer the case. TSA has, they still enforce the federal law going through airports. Obviously, it's not permitted on federal lands. The banking system cannot get involved in the industry. There are, barriers. Obviously, you can't distribute over state lines. Any business that has federal contracts is not going to be able to be involved in this at all. And there are some local bans to distribution. They can't ban use. So not everybody is on board here. And some, for very, very good reason, right? If you are heading up, public safety district, you're probably not going to be adopting an anything goes policy anytime soon. All right, so let's talk about some employer concerns here. Obviously, attitudes are evolving, they're shifting. There are ongoing developments in the market forces. So, this is a good time to plan ahead and think about, all right, so let's say we're still going to have a zero tolerance policy now. Is this always going to work? Maybe, maybe not. So here are some possible frameworks you can use, some options. Think of these as like off-the-shelf models that you can tweak and modify for your specific circumstances. There's the don't ask, don't tell model. There's the treat it like alcohol model. There's the treat it like prescription drugs possibility. And then there's the nope, no use, on or off duty, we're just not going to allow it. So let's talk about each of these in turn. Let's start with don't ask, don't tell. So the Health and Safety Code language, you've got the opportunity for a more liberal attitude towards off-duty use, if you wish, and if that suits the needs of your workplace. So what does that look like? Well, as long as an employee does their job, meeting standards, and you're not coming in with red eyes, stinking of pot, and, with fits of giggles, we're cool with it. We don't care what you do at home. That's the don't ask, don't tell policy. And that is perfectly fine. It's legal. It's actually usually manageable most of the time. And so a lot of employers have gone down this particular road. And let's think about it. This is kind of the default position. If you don't have a policy, this is pretty much your policy. This is, if you're not testing people under one of the permissible rubrics, then what people do on their own time, you're probably not going to know about it. So you're not going to be going after that. So now let's go back to our hypothetical. The employee really good employee, long-term employee, who has come to the ADA coordinator and requested to be allowed to use marijuana only off-duty to mitigate the side effects of chemotherapy. And let's assume, for the sake of this hypothetical, that this person is not on a leave of absence. They're coming to work, maybe taking a day off or so, when they have a treatment, but they're at the workplace. How would this person be treated under a don't ask, don't tell policy? Well, I think the answer is this would, depending on the nature of the person's job, this could work. So let's say this person has a desk job. As long as their private use of medical cannabis isn't interfering with their work, they are coming to work on time, they're doing their job, they're getting the work done, fine. Maybe they might need to sometimes come in a little late. Maybe those are accommodations you might have to consider. Whether or not they're directly related to the marijuana, it kind of depends on how the doctor writes the note. So you're going to be engaging in an interactive process with this person because of their medical condition overall. So if you have a Don't Ask, Don't Tell policy, you may or may not need to create an additional accommodation for this employee. You may just be able to say, cool, that's fine. This doesn't violate our existing policy. Let's look at the alcohol model now. So the alcohol model is similar to Don't Ask, Don't Tell. It explicitly allows for off-duty use of cannabis and, can more explicitly come out and say so. Obviously, you have to take into consideration the differences between alcohol and cannabis. The main ones being you can measure impairment by alcohol if somebody is drunk at work and, you have reasonable suspicion and you have this reasonable suspicion drug testing protocol and they come back with a .09, they are drunk at work. You cannot tell that just from a drug test with respect to cannabis. Keep in mind also that if you're going to treat all cannabis use like alcohol use, you may have a bit of a problem because while there's no such thing as medicinal alcohol, there's certainly 20 years of precedent for there being medicinal uses of marijuana. So you may have to explicitly deal with those in your policy, and that can still just be a no on-duty use policy. And obviously, there are different social implications and slightly different legal implications as well with respect to you can use alcohol in public in certain situations. You cannot use cannabis recreationally in public. You can use it medicinally in public in certain situations. So, it's not an exact match. Treating it exactly like alcohol may not work in every situation, but it's a decent place to start. It's a good way to frame a potential policy. So let's return to our beloved employee who is undergoing chemotherapy. How would this person's request be treated under a policy that said we're going to treat use of cannabis like we treat alcohol? Well, again, it kind of depends on what exactly the employee needs. They requested to use it off-duty. Well, does that mean off-duty right before work? Does that only mean off-duty right before they go to bed, so they'll be fine by the next morning? You may have to make some tweaks there. And, of course, you're going to have to respect medical privacy while you're doing that. Given that the person has volunteered treatment information in making the request, you might have a little more leeway there. It doesn't necessarily 100% solve the problem. But, again, it'd probably be workable. You could probably, if you wanted to, accommodate this employee's request if your policy were, we're going to treat it like alcohol. Now let's look at another model. And, what a lot of employers are doing is kind of a combination of 2 and 3. They treat recreational marijuana like alcohol. They treat medical marijuana like any other prescription drug that could impair an employee's physical and cognitive capacity. So if you have people who are performing safety-sensitive functions, it is fine to have a policy that says if you are going to be, if by reason of a medical condition or a medication your cognitive or physical ability may be impaired, you must notify us of that fact. We don't need details. We don't need to know what drug it is. We don't need to know what medical condition it is. Notify us of that fact, and we may temporarily reassign you. We may put you on temporary light duty, or we may put you on a leave, but you have to let us know that this is going to be the situation. You don't have to do this. A policy like this goes beyond what is required by law, but as you can imagine, like our hypothetical employee here, there may be instances where employers want to accommodate people in this way, and you can't wait until it's the beloved employee who wants to do this. You can't treat that person differently just because you like them, because then you are exposing yourself to all sorts of claims. So, best to think about these possibilities as you think about a policy that is going to apply to either all of your employees or discernible segments of your workforce. If you are going to treat medical marijuana or marijuana generally like a prescription drug, then you do probably want to make sure certain safeguards are in place. The most important of those being that you put the onus on the employee to disclose the fact, not the details, the fact, that they may be unable to perform their job safely for a period of time. You want to have safeguards in place, both in a policy and in the implementation of that policy, that is going to avoid a direct impact of the use of marijuana or any other drug on other employees. So, you know, and other employees, the same way other employees may have to shoulder a little more burden of the work if somebody is out on leave, that sort of thing is okay, but you're not going to have a policy that you know, is going to require someone to step in because their colleague is just too impaired to do their job. Obviously, you're not going to permit people to smoke marijuana anywhere that smoking cigarettes is prohibited, and you probably, you know, you're just not going to allow people to smoke marijuana at work. Obviously, you can't allow an employee to place others in danger, whether it's themselves or others in danger, through their use of marijuana. So if someone drives a company vehicle or an agency vehicle in the course of their work, they cannot do that under the influence. Obviously, or, you know, operating heavy equipment or anything else that's going to put anybody in danger. And your policy should specify that permitting, even if you're permitting use of medical cannabis and with whatever parameters, it can't unduly jeopardize the quality or quantity of the employee's work. So remember, even if you are treating it as a reasonable accommodation, it's not a reasonable accommodation to compromise the quality of somebody's work. Your general rules still apply, and you should enforce them as such. So, a caution here. This approach can't do it if you're covered by DOT regulations, and there's a decent chance it's not going to be suitable for, you know, public protection or other safety-sensitive positions. It may be. You could make it work, especially if you're going to use, you know, temporary light duty or, you know, temporary time off strategies to make it work, but it's going to be a lot harder to accommodate this type of policy, you know, especially if you've got, say, you're a small fire district or something like that. But, you know, depending on the nature of the work, the culture of the workplace, the community standards, this is a policy that, especially if you do the hybrid 2 and 3 alcohol prescription drug kind of approach, the upside of a policy like this is that it's more likely to have enough play in the joints, oh, terrible pun, sorry, to survive whatever changes might be looming on the legal and cultural horizon. So, let's say you're treating medical marijuana like a prescription drug. Let's go back to our hypothetical employee. How would you treat that employee's request under this type of policy? That's pretty straightforward, right? You would say, okay, we're going to engage, we're going to put some parameters around this. Is this going to require you to potentially be impaired at work? Oh, well, yeah, okay, so, sometimes I'll have to take some marijuana in the morning to offset some, morning nausea. Okay, so let's maybe adjust your start time on those days. Or let's say you take a day off on those days if it's, with any kind of predictability or whatever. This kind of a policy could definitely work for that employee. And our final of the off-the-shelf policy options is just say no. Nope, you cannot use marijuana on or off duty. We don't care if it's legal. If you're going to do that, you can't work here. It is perfectly legal to have that policy. Whether your labor market is accepting of that, that's a different question. But you can have that policy. And you know what? In a public safety department, in, safety-sensitive jobs, if you've got people working with power tools, that is still the most common approach. The only downside is that it doesn't allow for special situations. There are still ways around that because you have to think about enforcement. If you are not testing for drugs and somebody is using marijuana off-duty, how are you going to know about it? I mean, if somebody, squeals on their colleague and says, hey, I happen to know that Sally's got cancer and she's been using marijuana at home, I mean, then you're kind of in a bind. But what you don't know, you may not be enforcing. So let's go back to our employee with cancer. Under our hypothetical, if you have an absolutely no tolerance policy, well, then you couldn't accommodate that request. You would have to say, I'm sorry, we're going to have to figure something else out here. But our policy is our policy, and we can't allow you to use marijuana. And if you have a reasonable suspicion testing protocol, or you've negotiated some other type of testing protocol, or covered by whatever DOT regs where you have to test people, there just may be no way to accommodate this employee. Now, that doesn't mean, well, so what does that mean? Can't accommodate you. End of story? No, you still have to engage in a good faith interactive process about the person's medical condition. So maybe that means that you can't accommodate the request to use marijuana, which means that the person is going to be so sick after they have chemo that they have to take a few days off. You could give them that accommodation, which means that they'll still be able to be your employee. You just can't give them the accommodation they asked for. So it doesn't mean to be out the door. You just can't accommodate that particular request. This is, sort of apparent as we were discussing these options. It is absolutely fine to have a hybrid model. What I don't advise is having we're going to make this up as we go along model. It's important to think about these questions and how you would handle certain situations in advance, because if you don't think about them in advance, at some point down the line, if you handle different situations differently, you may end up getting accused of favoritism or worse. So this is a good time to think about what you want your policy to look like. So at the beginning of this presentation, we had some statements, and I said, let's consider whether these are myth or fact. So let's go through those again. First one, employers are required to have a cannabis policy, myth or fact? Myth. There's no legal requirement. It's a really, really, really good idea, but it's not required. Okay. Here's the next one. I actually saw this statement in, I can't remember what news article somebody made an assertion. Said, because drug tests cannot measure impairment by marijuana, employees cannot be fired for a positive marijuana test. No, that's a myth. So, and there's two circumstances or two instances in which an employee can be fired for a positive marijuana test. The first of those is if the employer conducts a otherwise legal test, so maybe a reasonable suspicion test, and has a policy saying you may not use marijuana on or off duty, we don't care, medical reason, recreational, nothing, then if you come back with a positive test, that employee has violated that policy. You can, in fact, fire them for that, even though the test itself doesn't show whether they were impaired on duty. That's not the test. If you have a policy that says no use, on or off duty, they come back with a positive test, then you can fire them for that. Use of medical marijuana must be accommodated under FEHA. I would hope after this discussion, if we got through anything at all here, you know that that is a myth. That's not true. How about this one? Employees cannot be fired for being impaired on duty. Myth. So again, you can't rely entirely on a test to show whether they were impaired on duty, but let's not forget our hot-smelling giggler with the red eyes. Yeah, of course you can be fired for using marijuana on duty and being impaired. Okay, and then finally, employee cannot be fired for being impaired off duty, also a myth. If that is your policy, query whether you can test that person legally and under what circumstances. But again, if you have, you know, somebody ratting out their colleague and you've got enough to go on there, yes, they can be fired for being impaired off duty if your policy prohibits that. So we've covered all of our myths and our facts, and I think I have used pretty much all of my time. I don't see any questions in the queue, so this must be an easier topic than we all thought. If you have any questions, I'll wait for a few minutes to see if any pop up. And if you have any questions that you didn't submit, then feel free to get a hold of us afterwards, and I will just say thank you so much for participating. I hope this has been helpful and useful to you.